Fantastic. So today this will be led by Michelle Quinn, who is a partner at RBS and co-chair of the Employment and Human Rights Group. And I'm thrilled to pass it over to Michelle.
Thanks, Sadie. Hi, everyone. Thanks for attending this webinar today. So I'm hoping you can see up on your screen the first slide where I just welcome everyone into the webinar. So today I'm going to be talking about mental health and addiction issues and accommodating employees in the workplace. So what I hope to do is to talk for about 15 minutes and then allow for some time at the end to answer any questions that you have. If you feel comfortable, you can unmute yourself and knock off your camera so that I can say hello to you and we can have a dialogue around this somewhat very sensitive topic. But we do have quite a bit of time. We have allocated about 30 minutes for questions and answers, so don't feel rushed. And there's no such thing as a silly question. So please feel free to ask as many questions as you like towards the end. So as I mentioned, this webinar, it is essentially about mental health and managing mental health issues in the workplace. Um, Recognizing and managing mental health issues in the workplace, the duty to accommodate, what does that mean? What does that entail if you're an employer? So we'll talk about the duty to accommodate under the BC Human Rights Code. The third part of the presentation will be addiction issues and accommodating individuals, employees with addiction issues in the workplace. And again, the duty to accommodate from the employer's side. And like I said, we'll have a question and answer session towards the end. So let's get into it. So employers do face challenges, unique challenges when dealing with employees who suffer mental health issues. Under the BC Human Rights Code, employers have a duty to accommodate employees who suffer from a mental health disability. So employee has a mental health issue, the employer becomes aware of it in the workplace, and it triggers the duty to accommodate. The code, so you'll hear me say the code, it's short for the BC Human Rights Code, prohibits discrimination on the basis of mental disability, which includes mental illness. Human rights duty bearers, including employers, unions, landlords, service providers, so if you're in any business that provides a service, all have a legal responsibility to respect these protections and take action to ensure that people with mental health issues enjoy a discrimination-free environment in their jobs, in tenancies, and access to services. So I'll give you an example. You're refused access to a hairdresser because the owner of the salon just feels that you have odd behavior and you're acting out of sorts. So when I talk about access to services, that's just one example. So think of any service that you get when you leave your home. It could be going to HomeSense, Home Depot, a hair salon, a restaurant. That's what I'm talking about when I say access to services. Some examples of mental disorders, including mental health conditions, are on this PowerPoint slide here. Depression, anxiety disorder, obsessive compulsive disorder, day-to-day stress or anxiety, do not trigger the duty to accommodate. We all deal with general stress in our everyday lives, in our jobs, managing workloads, but general stress would not trigger a duty to accommodate. Recognizing mental health disabilities can be challenging for employers, especially now when we're living in more of an age, if I can say that, where employees are working remotely from home. So how does an employer pick up on or be aware of an employee who may be suffering some mental health issues and have some challenges, where the workplace works 3 to 4 days a week at home, and in some cases 5 days a week at home. So that's tricky for employers. Generally speaking, the duty to accommodate is triggered when an employee has made their employer aware of a particular medical issue that requires accommodation in the workplace. The duty to accommodate has also been found where the employer knew or ought to have known. So I appreciate there's quite a bit of legalese there. So you knew, so it was quite obvious, or you ought to have known that the employee was suffering from a disability. So a very clear example would be where the employee comes in and sits down with HR and says, I'm really struggling with bipolar, I have a major depressive disorder, I'm anxious, I have this issue. So that's when it's clear the employee has communicated to the supervisor or HR that they do have a mental health or mental disability of some kind. So that's pretty clear, right? When we use the language ought to have known is where the employer or the supervisor or the HR professional picks up on some out of character, like really out of character behavior that wasn't demonstrated before. That now they feel like, oh, I think there might be there might be something up here. Maybe I should inquire. So the duty to inquire then is triggered. You are on notice, let's say, you've been made aware of there could be some issue with the employee that you ought to have now known about. If the employer suspects that an employee's misconduct or other behavior may be the result of a mental disability, the employer has a duty to inquire, as I mentioned, about the situation before taking any steps that would negatively affect the employee. So say, for example, you jump to discipline immediately, um, or you decide to terminate that employee. Um, what really you should be doing before you do any of that is to inquire and sit down in a confidential setting to have a discussion, a dialogue, a respectful dialogue, and coming from a good place. Is there anything I can do to help? I noticed this. Not to belittle or use condescending language. Try and be as respectful as you can, because you don't know what's happening with that employee. So the duty to inquire is important. The BC Human Rights Tribunal has held that behaviour which is sufficiently abnormal or bizarre can trigger the duty to inquire. Now, not every case, and I appreciate that this is a balance, you could have someone that's just having a bad day, and we all have bad days at work, and that's fine. But if you feel that you need to have a conversation with the employee to satisfy yourself, do you know what, they're just having a bad day, well, then go ahead and do that, right? Because you're in a workplace, the employee is entitled to feel safe. And so if someone's having a bad day, you're entitled to put it down to a bad day. But if there's something more there, then I would encourage the employer or the supervisor or the business owner just to make more inquiries. So I put up some examples here on the screen. Changes from past consistent behavior. So these are things that would trigger the duty to inquire. Work performance, which is out of the ordinary for that employee. So let's say you have an employee who always very good at deadlines, is able to work through their workload, shows up time for presentations, comes prepared, and has always been that employee who's prepared and very put together. But then you noticed well, they're dropping a lot of balls. They seem absent-minded, and they're not able to keep up with deadlines. They're falling behind on their workload. Whereas this employee, it's quite standard that they would always be on top of their job duties. So these are just some examples. Were that employee who was once very enthusiastic and, like I said, showed up to work on time, now there's a decrease. There is a clear decrease in interest or involvement in work. Lack of cooperation or a general inability to work with colleagues. So again, the employee who always got along well with others, their co-workers, collaborative, engaging, very cooperative, just wants to get the task done and work with their team members to achieve that goal. Now they seemed quite irritable and doesn't want to work cooperatively with their colleagues. So these are like red flags. Decreased productivity. If you're an employee that can take on large workloads, or you're very efficient, you get things done. And now what's happening is there's been a decrease in your productivity. Okay, so that's typically when you're productive and you're on it, your morale is generally speaking high and quite, you're feeling good in yourself. Whereas when your productivity goes down, there's a low morale there, typically associated with that, or one of the factors. So, excuse me, decreased productivity. Increased absences is a big flag. So if the employee was always on time, coming to work, doesn't call in sick, very reliable, very dependable, and now you have that employee who's now calling in sick on the Monday, always calling on sick on the Friday, and it's happening over and over again. I would say make inquiries with that employee. Have that, as I said, respectful dialogue. Sit down with the employee and find out what's happening and what you can do to assist. And we'll get into the duty to accommodate momentarily. Difficulty concentrating, making decisions, or remembering things. So in employees who were that are quite on it, and now they're demonstrating that they're quite scattered, they're really struggling making decisions, difficulty with concentrating and remembering. They're not keeping track of all the things that need to be achieved in the workplace. That's another red flag that would trigger the duty to inquire. As I mentioned, not every odd behavior will require an inquiry into accommodation. So for employers, being mindful and watch out for behavior that is so outrageous and it's really out of character, or unexpected, that it should have alerted the employer to the possible presence of maybe a mental health disability or a mental health illness of some kind. I have some files right now where the employers actually have noticed that the employee's productivity has declined. They're demonstrating erratic behavior, irritability, calling in sick, and I'm right now helping the employer navigate through the accommodation process and working with that employee to see what they need from an accommodation perspective. On the other side of my practice, because I work with employers and employees call me and say, Michelle, I've been terminated. I feel that as soon as I told my employer that I had bipolar or I suffered from ADHD, they amped up their discipline, and now I've been terminated. And at no time did they try and accommodate me. So these are the issues that I see in my practice when employers come and seek my legal advice, and then employees who feel that they've been singled out because they have a mental health issue, or they've been terminated because they shared with their employer or their supervisor that they have a mental health issue. So that's on both sides that I see. Where the employer fails to make inquiries and proceeds to terminate or otherwise cause a negative impact on an employee because of their behavior. And the employer's conduct may breach the code for failure to accommodate. So, an employer who has breached the code or has been accused of breaching the code, that's again the BC Human Rights Code, for terminating, disciplining an employee, may be found by the BC Human Rights Tribunal to have failed to accommodate that employee. The extent of the duty to accommodate, this comes up quite frequently in my practice where employers just don't know how far they need to go to try and accommodate an employee with a mental health illness. Um, and I've put it here on this slide. In essence, the duty to accommodate requires employers to make reasonable changes or to workplace standards. So very much the standard of reasonableness. So you need to make reasonable changes or to workplace standards so long as the accommodation does not impose undue hardship. And so your next question is going to be, because I get it all the time, well, what's undue hardship? Up to the point of undue hardship. The employer has a duty to accommodate up to the point of undue hardship. And I'm going to say every case is different and all facts of each case have to be looked at very closely. Um, Whether an accommodation reaches the level of undue hardship will depend on the facts of each case. Um, the employer is required to make reasonable efforts to work with the employee to see if the disability can be accommodated. And I will give you some examples of what accommodation, it's not up on the slide here, but I will just go through some examples of accommodations. So that includes modifying the employee's workstation. So it could be that the employee just can't work at a certain workstation and needs some assistance with either dealing with screens because it's too much stimuli, it's overstimulating, modifying the workplace station, providing the employee with adaptive equipment would be another example of an accommodation. Rescheduling shifts, another example. So if the employee has some anxiety and is, for example, and is having sleep issues, can't do the night shift anymore and needs to do the day shift, and the employer is um, going to work with the employee to modify their shifts. So rescheduling their shifts, tweaking the shifts in some fashion. Providing leaves of absences or time off work to attend treatment is another popular one I see. Just giving the employee a leave so that the employee can go and get the care and treatment that they need. Time off work, attend counselling, removing taxing parts of the job. If the employee has developed an anxiety disorder and it really is impacting them, removing taxing aspects of their job is another form of accommodation. Reducing hours or tolerating some absenteeism or relapse would be another example of accommodation. Relapse comes up where there is a drug and alcohol dependency, and addiction is covered in this webinar. So allowing the employee to attend a clinic for some time, but also allowing for relapses because that does occur. So the duty to accommodate the employee would factor in some relapses if that occurs. Relapses are to be expected in the case of an employee with an addiction, and that should be planned for and managed. Just before we move on, accommodations do not entitle an employee to underperform or engage in misconduct. So that's important for employers to be aware of that. Absent a link to a protected ground of discrimination, employers are still entitled to manage the workplace, including disciplining an employee with a disability for misconduct that is not connected in any fashion to the disability being accommodated. Employers are not required to create a new job for the employee, like an entirely new job, tolerate excessive absenteeism or substandard performance, or keep an employee in a position where they can no longer perform their essential duties. You've heard me talk about the employer providing accommodation to an employee with a mental health issue or an addiction dependency. Okay, so the employer has a duty to accommodate, yes, but there's also a duty on the employee. So there's a duty on the employee to facilitate accommodation. So the employer is participating in the accommodation process, and so too much the employee. It's essentially a two-way street, because ultimately the goal is to try and help the employee succeed in their job. An employee has an obligation to facilitate the accommodation process. And I'll quote now from the Supreme Court of Canada. The search for accommodation is a multi-party inquiry. So it's multi-layered. Along with the employer and the union, there is also a duty to the complainant to assist in securing an appropriate accommodation in determining whether the duty of accommodation has been fulfilled. The conduct of the complainant must be considered. An employee's complete failure to facilitate accommodation may excuse the employer from taking further steps to accommodate. Now, there's a case called the BC nurses case. I'll just give a high-level summary. And that considered a history of failing to address an addiction by an employee. The griever had opportunities granted to him from a previous job, and the current employer provided the means to monitor and maintain rehabilitation, which were ignored by the employee. So the employee completely ignored it. And the court determined that the employer's duty to accommodate the employee was matched by his duty to facilitate the accommodation process. The employee failed to discharge that duty, and the duty to accommodate was exhausted. Failure to cope with an addiction does not always justify a determination that the employee failed to facilitate accommodation. An employee is merely required to take reasonable steps, just like the employer, reasonable steps, and if the scope of the addiction is unknown, failing to seek rehabilitation will not automatically justify a finding that facilitation did not occur. So, in a nutshell, it's highly important that the employee participate in the accommodation process, and of course the employer accommodates the employee with a disability up to the point of undue hardship. Requesting medical information. I see this come up in my practice quite a lot because employers sometimes really struggle with what information they can request, what they can't. how detailed does it have to be? So I put on this slide where an employee, or when an employee, excuse me, discloses that they have a mental disability, the employer has a right to ask for medical information to support the request for leave or accommodation. The employer is only entitled to information that is reasonably necessary to assess the right to or requirement for a leave or accommodation. So that's highly important. The employer only has the right to ask for reasonable information that is reasonably necessary to assess what kind of leave the employee needs or accommodation. So you can't, as an employer, request to know absolutely everything about the employee's mental health issue or a diagnosis. Where an employer receives medical information, it is important that the information is only shared with those who need to know. And that's crucial to protect the employee's privacy. So, for example, supervisor, like a direct supervisor, human resources, key members of human resources, or the company insurer. The failure to protect the employee's medical information constitutes a breach of the employee's privacy rights and may lead to liability. So that's why it's extremely important for the employer to really make sure that the employee's information has been protected. And not everyone in the organization knows. It should only be the key people that need to know. So confidentiality is crucial in the accommodation process. Next up, addiction in the workplace. Now, I've already mentioned addiction a few times, but just to bring it back to the BC human rights legislation, does include drug and alcohol dependencies within the meaning of disability under the code, that's the BC Human Rights Code. Employers have a legal obligation to accommodate these disabilities within their organization. Accommodation could consist of, but is not necessarily limited to, tolerance of repeated periods of absenteeism, retraining, and or moving the employee to a different position where there is less responsibility, or modifying that employee schedule. And I mentioned that previously, that if the employer can revise shifts or reschedule shifts, that would be an accommodation from the employer. The goal is ultimately to try and find the balance between the rights of the employee and the ability of the employer to carry out its intended business without undue hardship. So you've got these two rights running alongside each other. So you've got the rights of the employee and you have the ability of the employer to be able to carry out its intended business. Now, what about a relapse? Because sometimes that does happen where employees are struggling with alcohol and substance abuse dependency issues. A complicating factor in substance abuse and dependency issues is that even if the affected employee seeks treatment and returns to active and productive employment, relapses are common and considered part of the disability. So the employer is still under an obligation to try and accommodate that employee who suffers a relapse. The employer may be required to accommodate several relapses and associated periods of absence for rehabilitation before reaching the point of undue hardship. And again, What does that look like? Well, it really depends on the facts of each case. Medical evidence is important. Where there is an admitted drug or alcohol problem, it is crucial that medical evidence is obtained from a qualified source in support of required accommodation. So, where you're dealing with alcohol or drug issues, it's very important that the employer has the most appropriate medical information from someone who's qualified, truly qualified to deal with drug and alcohol issues to help the employee. Sometimes a vague letter from the doctor may not do it. The employer, if it feels that it needs to know more or there's some ambiguity and they want to make sure that they are um, accommodating the employee properly, may have to go back to the employee and say, we don't have enough information here. We are going to need, for example, more detail on the plan for breaks that you need, how often, the frequency. Do you need to take something at a certain time? Do you need privacy for that? So sometimes there can be back and forth. From the employer with the employee to find out more information so that they are properly meeting the duty to accommodate. An employer is entitled to information, and it's quite detailed, this slide, so apologies, quite a bit of information on this slide, that includes but is not limited to the following. So this is what I'm talking about, the level of information specific to drug and alcohol dependency issues. So medical confirmation concerning the general nature of the disability and the employee's specific functional limitations, prognosis for recovery, the extent to which improvement is anticipated and or possible, and the associated time frame, and the potential for relapse. Functional limitations or restrictions that may be considered permanent, and confirmation that the employee is following any prescribed treatment and or rehabilitation plans, as well as identification of any medical side effects of such treatment that could have an impact on the employee's ability to safely complete job duties and or interact with others. So safety is an important key feature for employers. And I want to mention the employee and family assistance program that a lot of employers have in place, and because that can't be overlooked. So typically it's called the EFAP program. You may have heard of it. A lot of companies, a lot of employers do have this program in place. And if that is available as part of your larger company health and wellness program, the EFAP provides employees and their family members with accessible, confidential, and immediate counselling support for a range of health and wellness issues. I didn't put up on the slide, but for folks who register today, it's important not to overlook that that's a very important resource that's available to you. If your employer, your company has an EFAP program. Okay, we're doing good here on time. We're doing really good on time. Does anyone have any questions for me right now? Anything from mental health to drug and alcohol dependencies issues, the duty to accommodate? Because we're making excellent time here. So I'll open up the floor.
Hi, I've got a question. Uh,
Hi, Kate.
Hello, thank you for all the information. It's very helpful. I'm thinking about the how it if an employee comes and it seems straightforward. If an employee comes and says, "I have this mental health diagnosis," what seems more difficult is if they're saying things like, "I'm feeling overwhelmed, I'm feeling stressed," and is that considered that when they're saying those things, is that considered that they're saying that they have a mental health um, diagnosis, or as an employer, should we be um, considering that as a not as a diagnosis, but as a that start of, okay, we need to accommodate, or we need to inquire, I guess we need to inquire.
Yeah, great question, Kate. So, where an employee comes and says to you, like they have, I'm feeling overwhelmed, I'm feeling quite stressed out, um, my best advice I can give to employers is to say, okay, well, tell me what you need. Tell me what can I do for you? What are you struggling with? Do you need time off? Can we just talk about it, explore? And I find and you're right, Kate, like that is the duty. Now the employee is saying, and they may not, because they're probably quite uncomfortable, right? Because no
Hmm.
one likes to admit, I find anyway in my practice, because I act for both employers and employees. No one likes to have that conversation. So for an employee to come and say, I'm really struggling right now, and just to, like I say, approach it from a place of curiosity and say, well, what are you struggling with? This is between you and I. Tell me how I can help you more. What do you need from me? And just approach it from that angle. It could be, because I mentioned that, stress, the day-to-day stress of life
Hmm.
is,
Hmm.
wouldn't really trigger a duty because we all feel stressed at times and we're overloaded with work or tasks and stuff. But if employees coming and saying, um, well, it's something more. I cannot keep up. I cannot keep
Hmm.
up with this. I don't, and listen to them, right? What exactly is it that you have too much on your plate? Do I need to reshift the teams? Like, are you getting enough sleep? How can I help you? And I would always say, do more listening and find out how you can help. It could be that the employee is genuinely just a bit bogged down, like we all get bogged down
Hmm.
from time to time.
Hmm.
And it could be that they're just bogged down by this project. Okay, well, come from a place of compassion. We're all bogged down right now. But if they're saying, no, I can't concentrate. I can't concentrate. Because you always have to be alive to, depending on the nature of the workplace, is there a safety element? Like, are you working, for example, are you a are you like a support worker of some kind, and you're working with vulnerable um clients with functional or cognitive limitations? And if employees saying, like, I can't focus, I'm not paying attention on, like, I wouldn't be able to keep an eye on that client if the client got out and walked on the road. So it all very much depends on the nature of the role and the position. Because if you're concerned from a real health and safety perspective,
Hmm.
because the employer has an obligation to keep everyone safe in the organization, there could be a lot more questions to ask and just find out what they need. You can't go too far wrong, I find anyway, from taking that approach. And if the employee says, I actually feel I need some time off, and you could say, okay, well, tell me how much time you need off. If you could talk to your doctor and get me a medical note. Again, it doesn't have to go into a whole lot of difficulty, but there does need to be some kind, due to medical reasons, the employee needs to take a 1 or 2 weeks off. And there could also be, as I mentioned, that you might have the EFA, the Employee and Family Assistance Program, that, that might do it, or it could be more detailed, or it could be more involved. And you'll only find out once you continue to have this duty to inquire, is what gets it going. So it's
Hmm.
not a one-stop shop. I hope that helps you, Kate.
Yeah, no, that really does. Yeah, it's helpful that there's the step of just how you manage employees before going through that, of being compassionate, before going into a more strict duty to inquire and accommodation.
Yeah, because
Yeah.
because an employee initially coming to you, it really could be, because it all depends on the facts. It really could be like, the employee probably just wants to sit down and have a conversation with you with how they're doing, and then you saying, well, how can I help you? What can I do here? Tell me what you need, and we'll do our best to help you, right? Because
Hmm.
the employer has it's to act reasonable, right? It's not a standard of perfection, so it's all about reasonableness. And in order to help that employee, the employee also has to participate, because remember I said the employer is coming saying like, hey, I want to help you, but tell me how I can help you. And if the employer's like, oh, well, I don't know, and it's not very engaging, that's going to make it very difficult on the employer. So the more open the dialogue coming from a good place is always a really helpful place to start. It could just be that the employee is just really stressed out that particular project, or
Hmm.
it could be something a little bit more, that they're not sleeping, that they develop some sort of anxiety disorder. You won't know, and it's not that you're probing them. You're just saying, how can I help you? What can I do? What do you need?
Hmm. Hmm.
I hope that helps, Kate.
My other question is around, you talked about relapse with addiction. Does that also apply to mental health? Like that somebody may get help but there may also be a relapse with
Yeah.
anxiety attacks or something else?
Yes. Yeah. I see it more commonly, 100%, Kate. I see it more commonly with the alcohol and substance. But yes, mental health is a fragile, sensitive, um, issue, and it's got, there's a different spectrum to it, because you may just have something happen in your life that leads to depression, but you're able to move forward, and you can function in your job, and that's fantastic. But also there are cases where the employee does have a relapse, and they do, and it all stemming from the initial mental health, the mental disability, and it's come up again, and they may need more time off for treatment. So yes, in a nutshell, you can see it in mental health issues,
Mhm.
generally speaking.
Great. Thank you very much.
You're very welcome. Okay, does have anyone have any other questions for me? Sadie, do you have a question for me?
Yeah, actually, I took notes here because I was found it really interesting when you're talking about access to services.
Yeah.
Because one that I imagine comes up a lot that's probably a little bit more complicated is when you're at a bar and when it comes to serving alcohol when dealing with people who, you know, how does that play out when you also have requirements around serving and people's
Oh, okay.
erratic behavior that may be related to mental health?
Okay. So I'm properly understanding your question. So are you saying where the employer is a pub owner? Is that what you're saying? The employer is a pub owner and their employee has an addiction and they're working in the pub. Like, I'm just trying to
Yeah, no,
get a handle on
it was
the
sort of near the
question.
beginning of the presentation. We were talking about generally folks should always be able to have access to services like a haircut
Oh,
and things like
oh
that. But
yes,
what does it
sorry.
happen if you go into a bar and yeah, how would someone serving then approach?
Okay, so we'll we'll talk this through. So the employee, are we going to, or the individual? The individual has a drinking issue, is it? Goes into a bar, or has a mental health issue and goes into a bar, and the employer, the pub owner says, I'm not going to serve you, and I'm not serving you because you're acting erratically, or you're I think you're intoxicated. Have I got that right?
Yeah.
Okay. So when I was talking about, okay, so let's say I suffer from extreme anxiety, and I've got a major depressive disorder, and I walk into a bar, a pub, right? And I'm acting erratically. And the owner, or the server there, doesn't serve me. Um and they refuse because they say, well, you're a bit of a weirdo, right? Is that, I hope I'm not, I'm just trying to understand your question, right? So where where a service provider um discriminates discriminates against someone on any of the grounds that are protected under the BC Human Rights Code, that could expose that service provider to a potential human rights claim, potentially. Okay. So if I came in and I've got some issues, and the pub owner, for example, rather than say like, hey, take a seat, I can make you something else, or I can do something else for you, to kick someone else. And I realize this example is quite broad. You may be exposed to a human rights complaint, possibly, because the employer, or the pub owner, may have decided, um, um, has denied you a service because because they feel you have a perceived mental disability or mental health issue. Potentially that could expose them. Okay. A hairdresser, for example, again, you're displaying erratic behavior, but you just need that salon to just offer you a seat, and you'll sit down and you'll get your hair done. But just kicking the person out, saying, well, you seem like an odd duck, I'm kicking you out, again, could expose that um, salon to potential human rights claim. I hope that makes sense. It all depends on the circumstances.
Definitely. Thanks so much for clarifying, Michelle.
Yeah, because sometimes you could, um, y- sometimes service providers, they don't know how to deal with things, and their approach is just to, well, I'll just deny you entry. You seem like you're a bit odd, I'll just deny you entry. And then that individual will be like, well, the reason why you're turning me away is because I have this um I've got this mental health issue, and you didn't invite me in. You didn't even ask me if I could sit down. I would have been fine if you just put, me over here in the corner, but you just denied me access. You didn't do anything. That's more in relations to the kind of services. And sometimes you see that like in the news, right? Like there a couple of weeks ago, there was an individual with a guide dog, and the bus driver left them behind because they're saying, yeah, I'm not taking you. And that fellow brought a claim with the BC Human Rights Tribunal because they felt discriminated against by this service provider. The gentleman, the bus driver that drove away and left him there because he had a guide dog. So every situation has to be looked at. Anyone else have questions about addiction issues in the workplace, mental health issues? Either on the employee side or the employer side.
Okay, I'll ask another question.
Go for it, Kate.
Is about, so the thinking about the duty to accommodate, and you mentioned like that the employee has a responsibility to be part of the solution. But
Yeah.
I'm wondering about when somebody is in a severe depressive state, and they're not in a position to even be part of that conversation, and how as an employee, as an employer, the responsibility to go, like, is it to recognize and go, you're not in a state to talk about this right now, you need more time off, or
Ah, yeah,
how does that
so
work?
Kate, if I'm hearing you correctly, so the employee, they're in such a bad way that so they're coming to you, they're telling you they're in a bad way. Can I assume that, right?
Mhm.
They're telling you they're in a bad way, and you're saying, okay, well, tell me what I can do for you, and we'll take it from there. And then so you make steps to accommodate, but you feel that this employee is actually not, and not deliberately, it's not intentionally,
Mhm. Mhm.
that with their condition, it's overwhelming. In those situations, I would go back, because you want to make sure that you're meeting your obligation under the BC Human Rights Code. I
Mhm.
would go back and say to the individual, Okay, I think you need more here. I don't think this is working out um, as well as it should, and that's through no fault of your own. So please go back to your doctor and get me another note. It could be that you need more time off. It could be, and I just feel in order to make sure I'm doing right by you, I need to properly understand more. And that's fine, Kate. Like, you do
Mm-hmm.
need to know the employer does, in order to accommodate. I mean, you can't go with nothing. And if the employee is overwhelmed and maybe there just needs, and maybe another specialist needs to weigh in beyond the family doctor, right? Because sometimes you do need to get to a more qualified individual to handle whatever issue that is. And that's okay to go back to the employee and say, look, I'm trying here. I want to see you feel good and I want to see you succeed, but I do need something more from a specialist to tell me what else I can do here. Because it could be that employees just not getting maybe from the medical side
Mm-hmm.
the attention or the care that they need. Because if they're still functioning, or maybe they're not anymore, do they need time off? Do they need to take a leave? Does the employer now, because again, it's all about acting reasonably, does the employer now need to look at, okay, do you need to take time off? And we have a plan here. We've got short-term disability, we've got long-term disability. What else needs to be done here? Because currently, this situation that we have right now is not helping either side, because you've
Mm-hmm.
got the duty
Mm-hmm.
to accommodate and the employee has to participate. But they, if you can't help them if they're stuck, and it could be is because they just need more medical treatment.
Mm-hmm. Mm-hmm.
So don't be afraid, for all the employees and business owners out there, to go back and say, and I'm not saying, hey, we need to know everything about your business. I need letters. I need to see all your clinical records. Absolutely not. It could just be another letter detailing what you need in order to feel good, because you want to, you as an employer need to feel that you're not running afoul of the code, and you want to help your
Mm-hmm.
employee um get the help that they need.
Mm-hmm. Great. Thank you.
Yeah, no, anytime. Does anyone else have any questions for me? Big or small, or anything that they experience themselves, they want to just run by me. And I put my contact information here on the screen. I hope, Sadie, can everyone see that? If you have any further questions that you want to talk to me about afterwards, if you don't feel comfortable talking to me now. If I can mention something for the employers and the HR professionals here, it's all about acting in good faith. And I find if you're always acting in good faith and acting reasonably, you won't go too far wrong.
Yeah, I had another question too.
Oh,
I have some friends in my life who've struggled a lot with their mental health in recent times and are really worried about, having a very um, hugely increased workload, which is contributing to negative mental health, and feeling
right.
that having a lot of extra pressure on them is stopping them from moving up within the organization. Is there anything legally that can be done to support an employee trying to continue to grow within an organization, but feeling like
Yes, sorry to hear that, Sadie, but I will be, I am seeing that a lot, honestly, since COVID. And it's really helpful to have this dialogue, right? Because we're all coming from a good place here. I've noticed that since COVID, anxiety and people's stress levels have actually just increased considerably. So for employees in the workplace, as you mentioned, that are really struggling, so their workload seems to be causing, or is largely causing, the anxiety and the stress that they're under. Um, the way to make it bearable and helpful, if I can, for them to, as you say, succeed in the organization, if it's the case that their workload is just too much, has a conversation occurred between their boss and our supervisor that their workload, because if it's a workload issue, can that first of all be reduced or modified some in, in some shape or form. Okay. Now, if that's not the case and their mental health is suffering, and now they've been like diagnosed, they're suffering with some condition, if they are to continue, because again, it's about helping the employee with that disability, because mental health, so mental health illnesses and disorders, that's protected under the BC Human Rights Code. So if there is a mental health issue or disorder and the employee does need accommodation to help them, they need to go and have that conversation, because they can be direct communication um, with their supervisor or HR individual, um, or if they feel like I can't say anything, but I'm crying a lot at work, or just to give that example, or they're calling in sick, the employer should be on notice of that, right? Because if it's so out of character, like if the employees are your friends, if they were typically very productive, and now they feel like they're drowning, and now it's led to the development of a condition, a disorder of some kind, have the conversation in a confidential setting as to what they need to accommodate this mental health issue that they've now developed. And that's my advice would be to go about it that way.
Thank you so much, Michelle. That's really
Yeah,
helpful.
and also if they have, like I mentioned, the employee and family assistance program, like if there's any resource there to tap into that. Because I find that sometimes employees just forget about how useful their plans are. They can go for massages, and they can go to counseling, and it's all part of their medical plan, their extended health plan with the employer, things like that. Taking their vacation time. I know this might seem obvious, and again, I'm not trying to be patronizing here, but I do know of employees that are struggling, that are call me, and they'd say to me, well, I haven't taken a holiday in 3 years and I'm burnt out. And I was like, okay, so you need to mind yourself. Take your holidays, tap into your medical extended health plans, go get counseling that's covered as part of the employee and family assistance program. All these things may help. Um, so you've got them that may help. You may still need an accommodation. I'm not saying that you don't. I'm just saying start with things that are going to help you take care of yourself and your own mental health. Is any other questions for me? I'll stay on for a few minutes just in case.
Maybe not a question, but just another comment. Something I found really interesting in this presentation was
Okay.
how, I think sometimes for a lot of employees, it can be really challenging to disclose with it, there's still a lot of stigma with mental health.
Right,
And
yeah.
so it's good that there's, uh, you know, support from the employer that's required if there is a change
Yeah, I do find, Sadie, and I think that's really thoughtful of you to say that, because with the employers that I help on a day-to-day basis, like they really do want to help in whatever way they can. And they come to me for guidance. They want to help the employee who's struggling. Now that could be, just I'm going to say like general mental health, and then there is the addiction and dependency issues over here. But I find, given that you're right, it's still a sensitive topic, but there is a lot more awareness out there regarding mental health, and having a respectful conversation with someone you trust at work about where you're at and how you're doing. It could mean you need just time off. You may need something more. You may have a mental health disorder that you just feel like you could be thriving at work if you just got some more accommodation, right? And to go to HR, whoever is the designated HR, whoever is the designated employer, or if you don't have it, it could be a small business that may not have a big HR department, and it could be owner operated, and the one person is wearing the same hat. Just having that conversation And having the courage, I would say, having the courage to speak up about what you need, because you do need to be an advocate for yourself. And also if you have a good family doctor or practitioner that's going to help you, write that letter to spell out what is needed from the employer. Again, I do really feel that employers that I see in my practice do want to help employees succeed. So it's 101 and maybe people need to go back to work or do you want me to hang on for a few more minutes, Sadie?
Sure. I can turn off the recording to give people the time and space that they
Yeah.
need.
Oh, that's a good
Uh,
idea.